Thank you very much, Mr. Chairman. Let me just start by saying that on January 27, President Trump made an unprecedented and illegal move to fire two of the EEOC commissioners, Jocelyn Samuels and Charlotte Burrows, without cause. In the EEOC's 60-year history, the president has never fired a commissioner before their term expired. Commissioner Lucas, in 2021, you actually criticized President Biden's move to fire the former general counsel, calling the EEOC a, quote, independent agency. Now that President Trump is in charge, all the talk about the EEOC's independence has disappeared. These illegal firings are yet another example of the very long list of ways President Trump is weaponizing and making independent agencies political. In this case, the one Americans actually rely on for justice when they face discrimination at work. I led a letter to President Trump pressing him to reinstate Commissioner Samuels and Burrows. I urge my colleagues to join me in opposing any nominations to the EEOC until President Trump does that. Now, Commissioner, let me start with you on questions. Under President Trump, the EEOC has moved to dismiss cases they had previously agreed on by a majority vote to litigate. For example, the Commission recently dismissed a case, Lush Cosmetics, where the EEOC itself had alleged that a manager groped an employee, asked an employee for sex, commented on employees' breasts, tried to engage employees in sexual discussions, and used sexual profanities. Commissioner Lucas, was it your decision to dismiss that case?
Thank you for the question, Senator, and for the opportunity to acknowledge my prior tweet and to note that I was wrong at that time. At the time that I indicated
I'm sorry, you're referring back to the tweet about the agency?
The independence of the agency. And yes, that's directly relevant to your question because the agency is an executive branch agency.
Okay,
but at the time that I indicated that, I was not aware of the long record that the agency had taken that position. And therefore, it's important for, as an executive agency, us to follow the president when he directs us in an executive order to defend women's rights and to refer to individuals solely by their biological pronouns and to defend biological
can you
reality.
answer the question on the dismissing the case? You were acting chair of the commission when Lush Cosmetics.
Yes.
Was it your decision to drop the case?
It was my decision, in consultation with our career staff, unanimous decision of the career staff, that it was impossible to both comply with the president's executive order as an executive branch agency and also zealously defend the workers who we had brought the case on behalf. We could not balance both of those interests, and therefore we gave them an opportunity to intervene, and the case proceeds forward with those workers taking the position on their own.
Well, I just want to be clear. What you're saying is that when an employee is groped, propositioned for sex, and called abject slurs at work, the EEOC will do absolutely nothing to enforce anti-discrimination laws if that employee happens to be non-binary or otherwise doesn't conform to this administration's ideas about gender. Is that correct?
Respectfully, I disagree with that conclusion, Senator. What I am saying,
I don't know what conclusion we come to other than that with that decision.
As an executive branch agency, we are complying with the executive orders. Our doors, however, are open to all workers as statutorily required. We accept all charges, regardless of how they are framed or what they are indicated. And I've made clear in repeated statements that anyone can bring a charge. They will be treated professionally, and they will receive
I'll just say this for the committee, and I just have a few seconds left. It shouldn't matter what someone's gender identity is. If they are harassed at work, they should be able to get the justice they are entitled to under the law. I just have a few seconds left. I want to ask you about, in December 2022, Congress passed my Pregnant Workers Fairness Act, which requires employers to provide reasonable accommodations to employees' limitations related to pregnancy, childbirth, or related medical conditions. Most reasonable people would agree that recovering from needed abortion care is a condition that is related to pregnancy. You voted against PFWA's implementing regulations, and you've indicated that you intend to revise those regulations to narrow the situations the law covers. Do you agree that WFA covers miscarriage-related accommodations?
Senator, I do agree that it covers miscarriage related because that would be related to a childbirth. My vote to disagree with the implementing regulations came in as a disappointment to me. I advocated for the PWFA. I think it was an important bipartisan law.
Yes.
But it is important that the commission act with the scope of authority that Congress gave us, and we are not Congress. That rule, however, strove to displace Congress and to rewrite the rule in ways that exceeded our authority.
Commissioner Lucas, let me just say, and I am out of time, I recognize that. If it's necessary to protect a woman's health or her fertility or a fatal fetal abnormality, the law should cover that. And I find it really concerning that the commission doesn't agree with that interpretation of the law as we passed. Thank you, Mr. Chairman.
Senator Husted.